Welcome to Sakshi TV's special immigration show with attorney Mr. Chan Parvathaneni from managing attorney at law firm of Sim, Parvathaneni and Brown. Please note that Sakshi TV now has three immigration shows every week on Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Prashanti Reddy in English, and in Friday 6 p.m. EST with Banu Ilindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 866-725-7441. Before we begin the show, please note the information provided on the show is not a legal advice. It's for general information purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Mr. Chan needs no introduction. But if you need consultation, please log on to spblawfirm.com for contact information. When you connect with them, don't forget to mention Sakshi TV. From the beginning, spblawfirm.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The www.spblawfirm.com site provides you with the latest and cutting edge information on US immigration law and policies, explained in terms you don't need to be a lawyer to understand. Today's topic: recent employment based US immigration and H1B updates. We will continue the knowledge session along with the news and updates on latest immigration, followed by question and answer. Before we get into the topic, you can call us on the number on the screen for questions related to immigration and also ask for tips. Hello, Mr. Chan. How are you?
Hello, Swarna. Thank you for inviting me today.
Thank you. Before we get on to the topic, do you have any latest immigration updates about this week?
Sure. Hello, everyone watching Sakshi TV. It's an honor to be on Sakshi TV. Uh, Today, we have a couple of updates based on recent immigration happenings. Just today, we have the new visa bulletin for the next month of February. It just got released earlier today. There is some good news for people under EB1 and EB2 category for Indian nationals. The EB1 dates are still current, so that is good news. EB2 dates have moved by a couple of months. Now the priority date is January 2013. So that is very good news for a lot of people who have either filed that I-485 under EB2 or for people who have downgraded and have an approval under both EB2 and EB3, and their priority date is below January 2013. It's very good news for them. And the dates did go ahead for EB2. On the other hand, for EB3, there is not much movement for Indian nationals. So EB3, we have not seen the movement like we wanted. But again, based on what the Department of State has been predicting for the last couple of months, based on the news that is coming out, we don't really anticipate EB3 to move ahead a lot, even in the next couple of months and in the future bulletins. That being said, EB2 dates have moved ahead, so people might want to check with their attorneys, and if anybody qualifies either for filing for transfer of basis, they should be discussing with their attorneys. And on the other side, for the visa issuance, the US Department of State, which is responsible for the issuance of visas, has announced a visa interview waiver policy. So what that means is people now are able to get Dropbox option. They don't have to go for a visa interview at the US embassies in India. And they have a couple of restrictions on who is eligible, but more than likely it covers a lot of people, especially a lot of students who are here in US and who have received an approval for H1B visa. All of them should qualify. So it's a very good news for a lot of people who are already in US wanting to travel back to India but need stamping. This is going to help a lot of employees. So that's great news coming from Department of State late last month. And another news that impacts the immigrant community is that USCIS last week they came out with a notification, and they announced that they're extending the flexibility to answer the RFEs. So typically, whenever an RFE, a request for evidence, is issued, it has a deadline, and the USCIS, because of the COVID pandemic, has been extending the deadline for the last year and a half. And they came up with this new notification to extend that date further till March 26, 2022. So any request for evidence that gets issued before March 26, 2022 will have the deadline automatically extended by 60 additional days. And that would really help a lot of people to gather the documents because due to COVID pandemic, it's very hard to gather the documents in time. And this notification from USCIS will help everybody with a 60-day additional time to answer the RFEs until for any RFE that is issued until March 26th, 2022. That's in short for the summary I have for the recent updates.
Okay, thank you. So, what kind of flexibility is USCIS giving for responding to any request for evidences issued by them for various immigration cases?
So this month, USCIS has announced that they will extend the flexibility to respond to various requests for evidences or a notice of intent to deny or a notice of intent to revoke, etc. And they're also extending the deadlines for any cases that got a denial and where someone wants to either appeal it or file a motion for the denial. And so what they're basically saying is that if a request for evidence or a NOID, a notice of intent to deny, or a NOIR, a notice of intent to revoke, has been issued, and this is issued before March 26, 2022. For all those cases, what USCIS is saying is just add 60 days to the deadline that's on the notice. And that the deadline, that extension is automatic. So anybody that's in the situation where they have a request for evidence or a NOIR or a NOID to answer, look at the deadline on the notice and assume that you have 60-day automatic grace period. And this is applicable to any notice that is issued before March 26, 2022. More than likely, they will extend it even after March 26, 2022. We don't know at this point of time. But as of the recent notification, we have time for all the RFEs issued before this particular date. That being said, if a case is denied, so when a case is denied, typically the applicant has an opportunity to either file a motion or an appeal using Form I-290B. For those cases, USCIS is granting 90 days from the date of the denial to fight the denial. So previously, with the last notification, it used to be 60 additional grace period, 60 additional days, 60 days. The new notification, they made it 90 days. So now one has 90 days to fight a denial using a 290B motion or an appeal.
Okay. Thank you so much, Mr. Jan. So, what exactly is like interview waiver for H1B visa? Will someone on H1B automatically get the H1B visa in India without interview, like, visa interview? Has this already started?
So that is correct. The goal is people should now be able to get a visa without the interview. So in general, one has to apply for a visa at the consulate in order to get the visa. So they have to fill out the visa application, and they also have to attend a visa interview. However, now with the new notification, many people who have previously received any kind of a visa to USA. So the criteria is they have to receive a visa, any kind of a visa to USA in the past. So those people who are looking for a new visa, they will be eligible for this interview waiver. So what that means is that if somebody has been an F1 student in the past, they got a F1 visa in the past, they came to US and now they got an approval for H1B. They go back to India. Typically, they are supposed to get a H1B visa. And the way it works is they apply for a H1B visa, they get an interview appointment, they have to wait for the interview appointment and then get a visa. So now they're getting something, what is called an interview waiver. And what that means is they will be able to get the visa through the drop.
Okay.
Box appointment. And one interview. Also, the visa officers, because now they'll have more bandwidth because now they're not really wasting time in interviewing people and wasting their valuable time, and they can dedicate their resources to other things. So overall, this is going to speed up the visa processing, and more people will get a visa slot more easily. And over time, it's going to help both the employers and the employees and anybody trying to come to USA who require a visa, but they have received a visa in the past.
Oh, okay. Okay, this is like latest information we are getting to know. Thank you, Mr. Chan. So, what is the current approval rate of H1B filing? Like, are H1B cases filing denial issues in large number, like we used to hear about, like last 1 to 2 years? Like, is that what going on right now?
So in the recent times, we are seeing a large shortage of workforce in USA, especially due to the COVID pandemic, where a lot of people are not able to work or a lot of people have retired. So it is extremely challenging for the governments here in USA, the local state governments and the federal government, and also the governments all over the world. They're facing a huge challenge when it comes to the workforce because of the various lockdowns, various COVID issues. People are not able to work like they used to be able to work. And USCIS, which is the government agency that seems to be, uh, which is the government agency that is responsible for issuing the work permits, work authorizations. In general, they seem to be responding very well. I think they understand the labor shortage, and maybe the government administration has changed here in US. Overall, in the last 1 year, the denial rate has come down drastically. So, as per the current statistics, for 2021 new H1B filings, the denial rate is only 4%. And we can compare that to the denial rate 2 years back. 2018, it was 24% denial rate. 2019, it was 21% denial rate. So what that meant is 2, 3 years back, every 1 in 4 or 1 in 5 cases was getting a denial notice for a H1B application, for a H1B petition. So if the latest news is saying only 4% denial for the latest 2021 fiscal year, that is really good news. And again, that correlates to what we are seeing in our law firm. We are really seeing the approval rate is very high, the denial rate is very, very low. And that is great news for anybody who is well qualified and wanting to work in US. And this not only helps people who are trying to apply for a H1B visa, it also helps US as a country in general. The country is facing shortage of very well qualified employees, and keeping the denial rate so low and approving the cases for eligible applicants who are well qualified. That helps both the employees who want to work in US and also helps US as a country. We do expect the denial rate to be low going forwards, even in the next fiscal year. The only thing is that the denials are typically happening for those employees who are not well qualified. In general, if the employee is well qualified, the educational qualifications are good. We don't expect a lot of denials even in the next fiscal year.
Okay, thank you, Mr. Chang. So, before we go to the next question, so viewers, if you have any questions and would like to contact Mr. Chang directly, you can email him at chan@spplavfirm.com, or you can reach him out at 972-375-1000. So, Mr. Chan, when will be the H1B lottery starts again in this year of 2022? There was a talk that this year H1Bs will be issued based on the companies offering highest wages. Is that true?
Right. So last year there was a rule where USCIS said that from the next fiscal year, which is the fiscal year 2022, they said they will not do a random lottery selection, but they will look at the wage levels, and the companies that pay higher wages, they will be given preference. So they came out with that rule last year, earlier in January of 2021. And that was not fair for a lot of small businesses and a lot of non-profit companies. And lawsuits were filed. Lawsuits were filed in the courts by various organizations. And eventually the court vacated the order, the change. And however, USCIS has been defending the rule, and they wanted to appeal the court order. However, eventually looks like they made up their mind in the month of December. And late December, they announced and officially rescinded the final rule from last year. So basically, they said that they will not look at the wage levels to issue the H1B, the new H1Bs for the 2022 fiscal year. And what that means to us is that we probably will not have any changes from the way the H1B registrations happened last year. More than likely, the H1B registration process as well as the selection process. The selection process was random last year, and it will be random even this fiscal year. And the lottery is expected to happen in March 2022, which is about 2 months away. So, any employers who are looking to file H1Bs, now is the time to get ready. Start working with your potential employees, start collecting the documents, and get ready to do the registrations in the month of March. We're only 2 months away, and looking at where we are right now, it doesn't look like we will have any rule changes. It will be the same random process in this year's H1B registration.
Awesome. That's great to know. So, Mr. Chan, in order to work in USA, which is the better option? Do you say it's a H1B or is it L1? We see many Indian companies in either in H1B or L1. Can you please explain the advantages and disadvantages of both?
Sure. So many highly qualified Indians who are working in US, they work typically either on H1B or L1 visas. In general, H1Bs are more popular than L1, but we do have a large number of people who work on L1 visas in US. So for working in US, technically there are more than 20 plus non-immigrant visas, more than 20 plus non-immigrant visas where somebody could come to US and work in US. However, from the perspective of India, we typically have people come and work either on H1 or L1. For a lot of other non-immigrant visas that are available out there to work, Indians are not eligible for many of them. And for the ones that are eligible, typically the demand is not that high. So we'll narrow down the discussion to L1 and H1. And both L1 and H1 are widely used by software professionals, widely used by even engineering people like mechanical engineers, chemical engineers, civil engineers, etc. And these are popular visas, and these are typically visas that are given to very highly qualified people. And firstly, coming to the H1B visa. So H1B visa in general, it is used by somebody who has a 4-year bachelor's degree. So typically, a person who's on H1B visa, they have a 4-year bachelor's degree in a very specific specialty. And typically they come to work in that specialty. So if somebody has a computer science degree or an IT degree, they come to work in IT field or computer field. If somebody has a chemical engineering degree, they're probably working in a chemical engineering job, a pharmacist working in a pharmacy related position. So typically anybody who has a 4-year degree, H1 is a great visa to use. Coming to L1 visa. So L1 visa, it's an intra-company transferee visa. So what that means is that somebody is already working in India, for example, in that same company. Now they're coming to US as a transferee to work in that same company or a related company, like an affiliate. And because they're trying to come to work in the same company, we call it intra-company transferee visa. And it is typically used by such professionals. Typically, you have TCS, Infosys. They have people working in India in their India offices. And if they want to send them over to US to work for a long term, like a 3-year period, L1 is a great visa to use. So L1 is used by those professionals. So what is what is the advantage of using L1 versus H1 or H1 versus L1? H1 is a very flexible visa. You can work for any employer. Today, somebody can get an offer from a different company. A H1 transfer can be filed and people can easily jump to a new company. L1, on the other hand, L1 is for a specific company. You cannot transfer L1 like you transfer H1. So what that means is somebody is stuck to the company they're working for if they want to stay in L1 status. But why is it still used? H1, as we know, it's a very high demand visa. There is a lottery every year. So you have to go through the lottery. And if you're not picked up in the lottery, you don't have a choice. L1, on the other hand, there is no quota for L1. So if somebody is working, say, in TCS office in India, they want to send them over to US. L1 is a good option. There is no quota and there is no time frame limit on when you can apply, when you can start. For example, H1 always you apply it in March, you can start in October. So that's where L1 becomes more flexible for companies who are having employees work in foreign offices. They don't have to worry about going through the lottery, which is why L1 is used. So again, depending on what somebody's goal is, both of them are good options, and both are something that one can explore. My opinion is H1 is a lot more flexible. The only challenge is going through the lottery.
So, Mr. Chang, if people who apply for H1, if they don't get the H1 visa, are they eligible to apply for L1?
They're eligible to apply for L1 if they have been working in the India office or the foreign office of that same entity. Then
Okay.
they're eligible.
Okay. So apparently USCIS, the immigration agency in USA, is providing help to those affected by natural disasters and other unforeseen circumstances too. So can you please tell us more about that?
Sure. So USCIS, it offers immigration services to people affected by unforeseen circumstances or natural disasters. So typical examples are COVID. COVID is a very good example. It's a pandemic that nobody anticipated. Or, for example, a tornado or a hurricane. So when something like that strikes, USCIS has some policies that helps the immigrants and non-immigrants. Typically, when somebody is in US, they are supposed to apply for extensions on a timely basis. So before their I-94 expires, they're required to file for an extension. Or EAD card. If somebody's EAD card expires, they're supposed to immediately stop working. So that is where USCIS comes in and helps when there are unforeseen circumstances. For example, COVID pandemic. Somebody's in the country as a tourist and they cannot travel out of the country because of pandemic reasons. Somebody's immunocompromised or somebody is old and cannot travel because of medical reasons. USCIS understands that. For example, if there is a late filing because of such circumstances, USCIS understands that. So there are ways where USCIS offers those kind of help. So anytime anybody needs expedite requests, anytime anybody needs extensions, anybody needs help with late filings, and that is because of unforeseen circumstances, some pandemics or some natural disasters, they just have to request USCIS, and USCIS is considerate, even if there is a late filing because of such unforeseen circumstances.
Okay. So what kind of visas are in generally can be used to by, like, for artists, sports, athletics, and entertainers like actors or any musicians?
Sure. So professionals in various sports or entertainment industry, they often travel to US or they have a need to travel to US. And sometimes it could be due to work reasons. Sometimes it could be due to a need to participate in some event and various reasons. And business visa, sometimes business or tourist visa sometimes is not a good option because they might need to work. So in such cases, there are two good options. There is a P visa and O visa. And depending on the nature of one's case, people can explore those visas. So these are visas specific to athletes, artists in the entertainment industry, and other such professionals. So in this context, if say one is an athlete, a sports star, and they want to come to US to play in some sports event and so on, P1A visa might be a good option to consider. And if somebody's in the entertainment industry, the subcategory, the P1B visa might be something one could explore. And if one is coming to US to perform as an artist or an entertainer, the P2 visa is also another good way. And there is another option, the O non-immigrant visa. So the O non-immigrant visa, the burden is a little bit higher, and it is typically used by somebody who possesses extraordinary ability in science, arts, education, athletics, and they have a demonstrated record of extraordinary achievement in those fields. So this is it's a very good visa, O non-immigrant visa. And if somebody has achieved something of extraordinary, it's an extraordinary achievement. When you say extraordinary achievement, typically they're in the newspapers. They're public figures, something of that sort. O non-immigrant visa is a very good option. So P and O visas, are typically the visas that people use for athletes or movie stars or members in the entertainment industry.
Okay, that's good to know. So when someone on H1B or L1 visa travels into USA, we are hearing that at the airport entry of like they're checking for I-94 for small being like, some are being given for short in duration than the approval. So is that true? And what kind of precautions should one should take to avoid such kind of situations?
Sure. So when any non-immigrant flies into United States, when somebody comes into United States from abroad, they get a document called I-94 once they're admitted into the country. So this I-94 document, it's a very, very important document for any non-immigrant coming into US because the I-94 will have a date, and that is the date where somebody has to leave the country. So somebody either leaves the country before the I-94 date expires, or the other side is they have to apply for an extension. So they can either apply for an extension before the expiry of the date or leave the country. So what happens is a lot of times people assume that they get the I-94 date to match their, for example, for an H1B employee, they assume it will match their H1B visa or their H1B approval period. Or for somebody like a tourist, they assume it is given for 6 months, and they don't notice the I-94. So what happens is, if they don't notice their I-94 and the I-94 date expires, they become out of status and they accrue illegal stay in the country. So for that reason, anytime anybody comes into the country, into US, they are required to download the I-94. It is not given by hand. They have to download it from the website, from the CBP website. It's a very good practice. It's a required practice to download the I-94 and make sure they look at the date. So what we are seeing is, if somebody's passport expires before the visa end date, a lot of times people get reduced duration on the I-94 and people don't even realize it because the CBP will match the end date to the passport expiration date. People just assume because their H1B approval is valid or their H1B visa is valid, they're allowed to stay in the country. That is not the case. So as a practice, people need to make sure their passport is valid for a time that is longer than their H1B validity period. Or if not, they just need to make sure they look at their I-94. And if there is any issue with their I-94 date, either check with their attorney or check with the CBP. So that is very important. Otherwise, it is very easy for somebody to fall out of status if their I-94 date expires.
Awesome. That's great to know, Mr. Chan. So after H1B or any immigration application is submitted to USCIS, we routinely hear that the application has been issued on RFE. So what exactly is the RFE, and does insurance of RFE by USCIS means that they're about to deny the case? Is that the situation there?
Right. So RFE means a request for evidence has been issued. So a lot of times, if USCIS is satisfied with the application or the petition, they approve the case. If they're not satisfied and they find an issue, they issue what is called an RFE, a request for evidence. People get concerned when they see an RFE because in the past, 2-3 years back, RFE, there were a lot of denials. The rate of denials was very high. So people got concerned. So RFE does not mean somebody is going to get a denial. All that means is USCIS is not satisfied. There are some issues and they want people to submit more additional documents to resolve the issue. So whenever somebody sees an RFE, they just have to see what exactly is happening, look at the issue and submit the proper documents. USCIS gives enough time. There is a lot of time to answer the RFE. They will also put the deadline on the RFE. It is very critical that the RFE is answered before the deadline expires and all the issues are answered. I mean, if they're raising multiple issues, one has to answer all the issues. If an issue is not resolved, it's not answered, it could lead to a denial. But in general, assuming that all the issues are answered, documents are provided, typically it will result in an approval.
Awesome. So thank you so much, Mr. Chan, for providing all the information. So this has been a very informative session. So this is Swarna signing off. You're watching Telugu Prajala Sakshi TV. Namaste.